Everyone, this is Empress Ninti L. Bay. Today's lecture is going to be about the many methods that can be used to win a court case. In this particular case, I'm going to share with you the DA challenge. So, this is something that I've done personally, and I'm going to share the actual case that I was able to put together to win my freedom. So, there's many methods to winning a court case. In this case, we're going to go over the method of a DA challenge in order to win one's freedom. So here we're going to go over basically the fundamental things that you need to actually start and initiate a court case to defend yourself. A self presentation case is one that is where you are representing yourself on behalf of your straw man, which let me put that in the title. In court on behalf of the straw man. Okay, so there's a few things you need to know. Any court case that you have to lawfully represent yourself or go on behalf of the straw man. So let me share this with you. Okay. First off, you have to have your status proclaimed. Number one, declare your status. This is ultimately the saving grace in any case, any legal determination, any lawful act that you put forward. Number two, establish jurisdiction. You have to establish jurisdiction and you have to bring that lawfully before the court. Number three, do not accept contracts for which you do not agree. All contracts are voluntary. You have to know that. You have to remember that. Number four, become the master of your own fate. Establish your lawful stance in writing and verbally if you elect to enter into a courtroom at all. You have to first establish yourself. You let your paperwork precede you. Number six, do not contradict the lawful stance that you have already elected. So that means, let's go over the meanings of what I'm saying here. Okay. So this means that regardless of what is going on, how they are attempting to railroad you, force you to assimilate, whatever the case may be, after you have already elected your status, put that on the record, lawfully establish that for the record. This means that you must stand on that. You cannot deviate from that no matter what. So, number one, you have to, no matter what, whatever the case may be, if it's a situation where the DA is working for the state and is trying to force you into a situation, and most times that is the case, you want to first challenge the DA and challenge their uh, claim against you. So in this lecture, I'll be dealing with the district attorney who is working for the state, okay, or a federal prosecutor, same thing. Therefore, once you shut down the DA, the case is then closed and dismissed or abated altogether for the record. Your status determines how you will be treated legally. Okay. Number two, regarding jurisdiction, this means that you must inform the court of the proper jurisdiction that governs you and your affairs. So you want to make sure that you have lawfully put it on the record what you stand for. What's your status? This must be done lawfully. Affidavits and certified copies stand as law in a court of law and on the record. So make sure that you lawfully put these things in the record, your status and your proper jurisdiction. Okay. Number three, regarding contracts, revoke, cancel, and rescind all contracts that do not represent your status. Again, this is why status is so important. You can rescind contracts, such as probation. You don't have to be forced to assimilate. Number four, regarding mastering, you must know what you're doing when you stand for yourself or present yourself on behalf of the straw man. You must know what you're doing, and you have to have the confidence to stand on your square no matter what the outcome. You must dictate how the situation will end. Remember, you are the live, living flesh as opposed to a corporate entity. By law and by universal law and by right, you are the governor and the master of that courtroom. But because you don't know this, they're able to throw you around like a rag doll. So you have to build the confidence. You have to know who you really are, and you have to know how to handle being in these type of environments. Okay, because the main thing that they hang their hat on and how they force people to assimilate is by fear. Of course, at this time, they have the strong arm of the court. So that's where we get into number five. Okay, regarding number five, the lawful stance that you take. You must be able to articulate the lawful stance you are taking with the court in a clear and concise manner. That means that don't send them a pile of paperwork like this with all this different stuff in it from all these different processes and all these different groups. That is going to get you hung because they know you just throwing a bunch of stuff up against the wall to see what's going to stick, and that you really don't know and you're not sure about your stance of what you're claiming. Okay. Number 6, regarding what you say in court. Your stance, whatever it is, whatever your status, and whatever you're claiming. Okay. You must put that in writing. Your paperwork must precede you. So whatever you're saying in the beginning, as far as your status, your jurisdiction, and how you should be handled by the court and by any legal system or entering into any contract, you have to dictate the terms from the beginning. And the terms are set by who are you? What is your status? The jurisdiction of the land. So that has to do with all legal contracts, lawful representation, dealing with business upon the land and courts. Okay. When you indicate that a court does not have jurisdiction, yet you are standing within the confines of that court, that is a contradiction. So you cannot contradict what your paperwork has already said. That means do not back down, even if you are threatened with jail time. The court or jail can only hold you for a maximum of 90 days in worst case scenario. Now, that's better than being railroaded into 5 years of your life on somebody's probation. Because that's basically how they get you. That's how they get people in any of these court cases. They make them take a plea. They put them in fear. They hold them. And, it's just a strong arm tactic. But if you know what you're doing, you won't serve any jail time. I have never served 90 days. I have only served, it wasn't even a serving, it was just a contempt. Okay. Um, but that was 2 weeks at most. And that was because of political things. My situations, I have come to know the framework of courts and jails and different things like that because of the political climate that I'm in, which caused the powers that be to want to try to make me a political prisoner, try to break me, whatever the case may be. So I know what I'm talking about. I know what it takes to sustain these type of ordeals. So this is what this lecture is about. They tried to force me into probation, which probation is a contract that you do not have to accept. Pre-trial is a contract that you do not have to accept. Any offerings from the court and district attorney, such as a plea bargain, are contracts that you do not have to accept. But because most people are in fear of what will happen after they're threatened with so many years or whatever this DA, district attorney, is going to tell you to put you in fear, to get you to agree to something. Remember, they don't have anything unless you tell them something, unless you agree to something. If you do not agree, they don't have anything. It's all a contract. And you can't let fear, you have to stand your ground, you have to stand on your square, and you have to know that All of this is smoke and mirrors. It's all a contract. It's all a business. And it has nothing to do with right or wrong. It never has anything. I don't care how many trials, how many OJ trials, or whatever they put on TV. It really has to do with politics. Most cases go to trial and are blown all out of proportion on the news and things like that because it's political. It has nothing to do with the law. So I want everyone listening to just be aware of the system. Okay, the system is the court system itself. The entire court system, jail, judicial system is like a bank. It's a banking system that runs on currency. Okay. In this case, who is the currency? Humans. Humans are the currency. So all crimes are commercial. That's dealing on a federal level. And all um, charges on the state and local level are contractual. The currency in this case, like I said, which is the human currency, it's used by those who are stakeholders in these courts and jails, the owners of these courts and jails, a way for them to make money. And they bring these cases in the name of the state. So half the time, these policy enforcers, who they call police, they don't even know what you're, they don't even know the dynamics of what they're doing. There's so many times that I've put a police officer on the stand and asked them, do you have a claim against me? Have I injured you? You know, these basic questions, this basic lawful questions. You brought a claim against me. That's what this citation is. It's a claim that you signed. What did I do to you? These are questions they cannot answer. They're bringing the case in the name of the state, always. And like I said, it never has anything to do with law. It is just a cash register for the state to keep making money off of human chattel. So these entities are set up like a trust. And these officers bring cases, bring money into the bank, which is the court, in the name of the state because they're trying to make money for the state. So these cases in district court, lower court, local district court with district attorneys, they are working for the state, all of them. Okay. And the trustee is working for the state. Those cases are brought before the court by and through the trustee. And guess who the trustee is? That is the head clerk of that court. That's the trustee for the state. These entities are set up all like a trust. I talk about the power of trust in my Ultimate Guide to Freedom Trust lecture. Okay, you may be asking, did these methods work? These methods I'm talking about, and will they work for you too? The answer is yes and yes. Now let's take a look at how I handled the DA. This was 1 year I was railroaded. I think it's 2016. I'm getting ready to pull up the case so you can see it. CMPD police in the city of Charlotte. Um, they tried to railroad me on some trumped up charges. One thing is clear, these methods worked because I'm still free, never served any jail time or probation. In fact, while the media had all of these false reports out and the court continued to run false court records in my name, indicating that I served 22 years. In some cases, this was in Florida. News reporters were saying that. And in North Carolina, they had in the records that I was on 12-month probation when I was actually in Africa. The whole time they were saying all of these things because they kept my name and the case rolling for at least 3 to 4 years after I had put my stuff on the record, smashed them, and walked away, and everything. But they was trying to hide it. Okay, it was all political. So this is when I began to really know that there's certain powers that be that if they don't want something in the media or in the public record, they know how to manipulate that situation. So this is when I really became wise on the dynamics and what is really going on here. A lot of folks never really knew the magnitude of what I was dealing with. Um, these shots were being called from high up. Anytime you can leave something in the court records when you know it's dismissed, or anytime I put a case to the Supreme Court of North Carolina and get back one page with one word on it, denied. That's what let me know that it's some power players that's giving orders to these courts and judges. And, fast forward years later, I know exactly who it is. But back then, I was, spinning my wheels, hitting these courts, going back and forth, smashing them. They couldn't, I was winning every time, but they would never outright say it and give it to me because somebody was telling them, certain entities was telling them, don't give her nothing. Anytime a Supreme Court issues an opinion, or answer, they have to issue an opinion. So that's how, that's one thing that let me know that it's not about right or wrong. It's about who's politically pulling the strings. There's no way a Supreme Court is validly going to send someone a response that's on a blank piece of paper and with one word on it that says denied. So that's just an invalid response, especially dealing with a Supreme Court, a court of that level. So that's when I began to come forward into and blossom into the whole status side as far as tribal governance and being able to resurrect an empire state and tribal governance upon the land. Um, so let's take a look at the case that I'm talking about, the DA challenge, one of the cases that I got dismissed. So the way that I handled this case was the method I used was the DA challenge, because most of the time when they bring a case, it's going through so many different hands. And a lot of times, like I said, the police, they are just there to bring in the stock, to bring in the chattel paper. So they're writing up cases on people and they always say, well, let them figure it out in court. They don't know nothing. Their job is to get a quota get people in here. We need to make money. So it goes into the court system. Now, if it's unlawful or not, the DA got to figure out. All of them work for the state. The DA is trying to figure out, how can we make this stick? They brought it in here. Now let's see if we can make it stick. And that's what they do. It's not like, it's lawful. It's just a job for them. They're trying to figure out a way how they can keep you in there. Even though most of the time these police officers are violating all our constitutional rights, and if you claim to be indigenous rights, it doesn't matter. They are there to make the money. So the method that I used with the DA is to challenge their process. The process is 99.9% always flawed. They never follow procedure. They never follow due process of law because they are simply trying to make something stick. And it's not lawful to begin with most of the time when the police bring this situation, this case into the court. So now the DA is challenged with trying to make it look lawful. So in this case, my method was to challenge all of, because that's a gift that I have. I could see immediately each case. It was like 7 cases. It was just a bunch of gibberish with all different kind of charges. So each charge, I was able to see the flaws in the charges. So I challenged the DA on the process. So every charge has to be accompanied by a certain process. And if the DA does not follow that process, it has to be thrown out. So you can get a case thrown out or demand that it's abated altogether. A lot of times I would do that, just get it abated, and it'll never hit the record. Now you got to follow up on those type of things and make sure they take it out of the record, because if you don't, it'll just sit there, because that's just what they do. So now the things that are required for this type of case, which I like to call the DA shutdown. Okay. You must be willing to self-present or act on behalf of the straw man in your case. You have to know how to stand, and you can't go in there with any type of fear. So just eliminate the fear, educate yourself on what needs to be done, go in there like business as usual and handle your business. If you are confident enough to go in there, okay? In most instances, if you lawfully put on the record certified copies and affidavits of your status, and if your status does not include, if you're not seated in that venue with your status, then a notice by affidavit or certified copy is sufficient, and you at law shouldn't have to go back in there. But so that's basically what I do now, unless I am going after a case after someone, or in suit or pursuit of someone, then you go in there. But if you are asked to go in there, summoned, that is a voluntary contract. just like taxes are. That's a voluntary act. They, of course, put you in fear because they do all kind of unlawful stuff that don't follow due process as well, you know. So you must have yourself in a position where you can represent the straw man. No attorneys can be involved whatsoever. That's the only way you going to, put it down like the Empress does. You fire the attorneys right away, because what's going to happen is, by your tacit agreement, acquiescence means you agree to have this attorney represent you. That is an officer of the court. You automatically in their jurisdiction. So everything that you have said, as far as this is not my jurisdiction, my status is this, this, and this, you know, they don't have to respect that, because your actions have contradicted already what you said. This is why they slam dunk a lot of our people around and throw them around like a rag doll, because they don't really understand the dynamics of what they're doing. Okay? You can't mix apples and oranges. If you tell them your status is this and your jurisdiction is this, then you can't go with this. And a judge, a district attorney, a court appointed attorney, all of them are with this. All of them are on the same side. So you can't have nothing from that side. You are totally a total separate entity from them. So that means you have to learn how to stand. Okay? Because if you tell them one thing and then you do another, guess what? This is gonna override what you told them over here. So you can put on the record all you want to, that this is not your jurisdiction, blah blah blah, and then you go in there. Okay? So now you teetering. And they're saying, well, they're saying this, but they're here. So now the judge has physical power over your body. You see them sheriffs in the courtroom, right? So you have given them persona jurisdiction. They have to have subject matter and they have to have persona. Oh, that means jurisdiction over your person. You giving them that. I know it sounds hard. I know it sounds, crazy, but this is the law. This is what they look at when they say, people, Moors or indigenous people don't really know what they're doing because of your contradictions. So if you tell them one thing, but you're doing another, they are going to, pretty much slam dunk you. You can't do that. You have to stand on your square and stay there. If you put that on the record, it's on the record and you properly do that, lawfully give notice, that's it. By law, you are, by law, you have given your notice. If you do it right, you do it lawfully, you have given your notice to the court and you have made your appearance. You don't have to take your body in there to make your appearance. But of course, they have the strong arm to try to force you to assimilate. Me, I'm too stubborn for that. I already know what time it is. I don't care how many times you threaten me. I know the law. I told you who I am. I put it on the record lawfully, and I've noticed you lawfully, and that's it. I'm not going back. I don't care how many times they try to roll the case over and put my name out there and try to defame me to the point where they thought they could pull me back into the court. I'm not I'm not going out like that because I know better. That's how strong, when you take this stance, that's how convicted, you have to have strong conviction to fight this system that we've been forced into. If you don't have strong conviction, then you can't do this type of work. This is work. It takes work. It takes work to have your freedom these days because there's entities constantly working to take away your freedom. Trust me. Take away your freedom, take away your livelihood, take away your health. They have a system. They systematically work at this day in and day out. Okay. So if you're not ready for that type of fight, or just, it don't even have to be a fight, it's just a diligence about yourself and a way of life. Okay. So the third thing, you must lawfully file your response for the record in an inconspicuous lawful manner. Okay. So now let's take a look at the case. I want to show you how I dealt with the DA. Okay. So this is the case that I won. This was a case where I challenged the DA and I won my freedom. And this is the same case they tried to say that I had probation, but I have the recording of the probation officer actually calling me and letting me know, Miss Elbay, you can come in. And there's just one piece of paper I need you to sign to make sure you don't come in or have to come in for probation, blah, 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 blah. Only time I spent on probation is when I walked in there and I confirmed that I was not doing probation. That was it. So these people have it already planned out during this court trial, which I found out later was not even recorded for the record, and you couldn't find it anywhere the next day. And they told me they don't record these local or district court cases. And I'm like, but the news media is here. You mean to tell me the court did not record this? So this is how fraud it is. This is how fraudulent all of it is. So it's just, it's just something that we have to deal with, and hopefully we will, more of us will be able to prevail and be able to stand without fear and without being railroaded into a system that is not designed for law. It's designed to get as many people into the system as possible. So this was the DA challenge. Let me see, can I read it? It's coming up kind of small. Let me see. Pull it up on my end. Okay, so this was March 29th, 2016. I filed this. Okay, so this was me. First of all, in any situation, you want to give the other party an opportunity to cure. And that's my biggest thing. It's a noticing process before you set out to take your own remedy. So for me in this area, they know that when I'm sending them an opportunity to cure, they know I'm setting them up for a lawful remedy, which in my case is going to be a lien placed on their bond or placed on their official seat, official capacity, social security number, whatever I can find on them. I'm going to give you this opportunity to cure. In the event you do not cure and see and correct your wrongs, then I'm letting you know I'm going to take a lawful remedy in which I set forth what the remedy is. So I didn't take pretrial. This was an opportunity to cure abuses of process. That's a legal term. And flagrant violations of the United States Constitution pretrial requests. So they try to force you to assimilate. And another thing they do, they do variations of your name. So they'll play a game. Like if I give a notice, I've given them so many notices in Ninti El Bay, which my name does not have, my title does not have a dash in it. But they know that, and they will put the variation of the name with a dash in it and bring cases against me, knowing that that's not the way my name is on any legal document. So watch for that. If you have given a notice of indigenous status or you are not within their system, whatever your stance is, take note of that. And also, they're gonna put it in all caps. Of course, we know that because that's the birth certificate. That's the birth certificate, which they have. They are the trustee over that, unless you take it back, like most of us did years ago. Um, with the UCC statement, or some people filed a state um, claim on the name and stuff like that. Like I got a trademark on NTL Bay. This is what, some of the things you can do to take back the titles and names and birth certificate chattel paper that they have taken hold of and are using it as trustees and as correspondents. They call it their correspondence. So you have these fiduciaries on your stuff and you don't even know that they're using it, they're making money from it, they're doing whatever they want to do with it because to you, you're a minor and you need legal representation. And so this is what they're doing unbeknownst to most of us. Okay, so Empress Ninti El Bay requests to the district attorney to review the district court trial cases for flagrant violations pursuant to the North Carolina statute. And it says in that statute, flagrant violations. That is not a word that I came up with. That is actually in the law. Number 2, requesting discovery pursuant to North Carolina statute, disclosure of evidence by the state, information subject to disclosure, requesting all evidence listed below pursuant to the North Carolina statute. So these are all of the statutes that I held them to. This is a statute specifically for the district attorney. They have a law and protocol that they're supposed to follow. Each and every last one of these officials, they have a bond and they have a title of duties in the law. So you find that and you hang them on that. This is when they know that you can articulate yourself and actually find uh, their duties in the law, then they know you know a little something, and they not trying to play with you no more, basically. So this was just so many things that the DA didn't do, and they were still pursuing. So the district attorney has all of these underlings who are assistant DAs, and they just do what they want to do because they're trying to make a name for themselves. They're trying to get another one under their belt. They're not following the law. They are not following the statute. So this young lady here, I I sent her an email. I wonder if I can find that email. I sent her an email, and the sister that was there with me, she was like, "You think she gonna listen?" I told her, I said, "Listen, I'm giving you this lady right here. She was an assistant DA, Emily Poe, and they had me all over the news. So she was trying to make a name for herself." And I emailed her and I told her, I said, "If you don't correct this case with all of these duplicitous charges and this, and this, everything I told her, I said, the DA, I'm going to fry his ass basically, and he gonna throw you under the bus if you don't correct this stuff." So she didn't think I had the chops. So after the trial, the next day, I see her with her little box walking across the street, and she ooh, her face was so red, and she turned her face the other way. She didn't want me to see her. And the next few days, I went back in there to the office, and they was like, "No, she's been moved to juvenile." I bust out laughing. So she was this big DA, assistant DA, trying to work her way up. They demoted her down to juvenile cases, and she was no longer in the district attorney's office. Now that's how confident I am. I thought it was so funny because these people think they so high and mighty, walking with their little crew. It was always 4 or 5 of them around her. She was the big honcho, blah 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 blah. Oh, I couldn't wait to take her down. I gave her opportunity to cure. So it's not my fault that you in the kindergarten league and you can't practice no more in the district attorney's office. So this is the things that get my goat. Okay, that when I can do that, stand my square and keep my freedom and smash them at the same time, I love it. That's the only thing that gets me going. In a long time, I can say I haven't had a challenge because everything was always easy to me. This right here, I had to learn. I had to fight to learn it because I'm not going out like that. I'm not letting these people railroad me on some false mess. So, yeah, I became very good at it. As you can see, I'm still free. So, these are the authorities. So, this is the way I wrote this up. Okay. Let me see if I can move the pages over so y'all can see more. Okay, page 2. And hopefully it's not too small. So, this is the case, the actual case that's going into the DA Challenge lecture that will be offered for purchase on my website and on YouTube with a link that is attached to the lecture where you can purchase this. If you want to have a custom template made for you, you can do that as well at cost, and it's very thorough. I didn't leave any stones unturned, of course, because I was fighting for my life, my freedom, and eventually won, and never served any time, any probation, or anything like that. So I'm here just to let you all know that this is possible. Do not let these people put you in fear. Do not let these people railroad you. Don't take anything. Don't lay down for anything, because I'm telling you, 99.9% of all of it is made up. It is just something to try to get money into the system. It's not a matter of right or wrong. It is simply a matter of getting bodies into the system, and that means probation. A lot of stuff they're doing now is in these mental hospitals trying to commit people. It is crazy. I'm telling you, if you don't learn how to protect yourself spiritually, number one, learn a little bit of law so that you can keep you and your family free, because they are constantly coming. And health wise, it's just what it is right now. Until we can get our own communities up, governments back up running, we are subject, we are being bombarded at every turn by those who want to extract something from us, especially us, you know, the aborigine of the world, of the planet. We're constantly a target because they know who owns the land. They know who the proper heirs and the rulers are. So they always come in trying to diminish us, trying to come up with all type of vaccines to dilute the bloodline. That's another story for another day. So let me just read some of this. Okay, these are the laws in every state that you can challenge the DA with. Disclosure of evidence, okay, by the state. Information subject to disclosure. Upon motion of the defendant, the court must order, yes, it must order, this is in the law, the state to make available to the defendant the complete files of all law enforcement agencies, investigatory agencies, and prosecutors' offices involved in the investigation of the crimes committed or the prosecution of the defendant. Now, they didn't do none of that because they didn't have nothing. And if they did have it, they didn't want me to see it because it was even more fraud to be found. So they didn't produce none of that. Just I didn't even this is just the second page. It's 6 pages. So you can imagine what all I hit them with that they didn't do. Like I said, I didn't leave any stones unturned. Just this is one method I've used in the past amongst many others. Okay. What's another one? It's let's see. Okay, the authorities I use, and it says must be dismissed pursuant to North Carolina General Statute 15A-135, allegation of venue conclusive in absence of timely motion. These people waited almost a year and a half to try to charge me with something. No, that got to be Just that alone has to be thrown out. They have to charge you in a conclusive venue in a timely fashion. Okay. Another one, must be dismissed pursuant to the sufficiency of all evidence introduced in a criminal case is reviewable on appeal without regard to whether a motion has been made during trial, as provided by North Carolina General Statute. It was so much that I hit them with. They couldn't get out of it. They couldn't get out of it. That didn't even go into the case. Okay. I had a lot more waiting for them dealing with these fake rogue police officers. We didn't even get into that. So after I hit them with this, got it dismissed, I went after them on the lawsuit. All of the fake charges and excessive force, abuse of law, all these other violations. But first, I had to get myself out of harm's way. First, I had to get myself out of harm's way, and then I could see my way to go back after them. So that is a good strategy that I recommend for anyone. First, you have to get yourself out of harm's way, and then you can deal with the rest later. So this is going to conclude this lecture, and I hope you got something out of it. You all share the content, share the channel. They, of course, do not want this information out there, and I notice my channel is being affected by the so-called powers that be. So share the information, share the channel, and give it a thumbs up, because that helps the algorithm or whatnot. And I'll see you on the next one. If you want more information or want a consultation, you can reach out as well.